We'll now cover company auditors, and the Act does not specifically define an auditor, and yet this is despite his essential role in the company. But he's an officer of the company for the purpose of a misfeasance under the Act. And an auditor is an officer carrying out duties in the sense of that word, an officer, but he's not liable if only he's appointed for a limited purpose. When you talk about an officer of the company, a director is an officer. We have talked about the company secretary being an officer of the company. And with these, we assume those managerial positions. An auditor cannot fit into that category, especially if he is appointed for a limited time. He's appointed to audit this financial year. So he is not an officer of that company. But he can be considered an agent of the members of the company in a certain respect, because his role is to ensure compliance. His role is to ensure the books of accounts are represented in a fair manner. But he cannot be an agent of the company if, again, he is not appointed to act out in the best interest of that company. So his role is not defined, but it is looked at in the relationship between himself and the company, himself and the shareholders, where his duties lie and where his obligations will lie. Because the readers of financial statements need to have a guarantee that they've been properly prepared and accepted under accepted set of conventions. Therefore, they need to be relied upon, and they need to rely upon the person certifying them as having been presented in such a manner. So what this means is that the auditors who are to be contracted by the company must be fit and proper to carry out the duties of that office of that auditor. And if reliance is to be placed on accounts, they should represent a true and fair view. And this will only happen if the person auditing is independent of the company, where they are under no obligation to put the company in a favorable light. Theirs is to be impartial to the runnings of the company and look at the books of accounts without having to go back and find out, is the director my friend? And during this period, January to December 2023, was this friend of mine involved in the active management of the company? Therefore, do I need to protect him and present a favorable report to the shareholders, since he's the one who has gotten me this job? He needs to be independent of that. His is to look at the books without giving due care or consideration to who these directors are and their relationship to him or to persons known to him. And this is why we are saying these audited reports will be relied upon. What is relied upon when a shareholder, when I want to buy shares in a public company, I will look at the published audited accounts and determine that this company is doing well. Therefore, I want to buy a number of shares that will earn me a return based on the projections, based on the past performance. So his independence is key. His impartiality is very key in that. And the Companies Act has attempted to ensure that the company's auditor is someone properly supervised and appropriately qualified. And the audits so done, they're carried out properly with integrity and a proper degree of independence. And this is what we are saying. You must be able to detach yourself from the relations of that company. You detach yourself with emotions that may occur or may not, that may mislead and interfere with your opinion based on what you have done. Having said that, we need someone with integrity and a proper degree of independence. What are the qualifications of an auditor? And one of the qualifications is that one must be a member of ISPAC. And for you to be a member of the Institute of Certified Public Accountants of Kenya is that you have finished, you have completed successfully CPA, the course you're doing. And upon completion, you have registered with the Institute of Certified Public Accountants, and you get your membership number. You have attended the requisite trainings. You're in good standing. And you are bound by the Act, the Accountants Act, to ensure that your role is held separate. Your duties are held separate. And being a member means you can also be disciplined if you act in a way that seeks to embarrass this professional body. And we have a situation where a firm of partners may be appointed as auditors, unless it's contrary against the Articles of Association. So when we talk of an auditor, it may not just be an individual person. We have audit firms. We have KPMG. We have any other local audit firm that may be appointed. The company may appoint that firm, and the firm will determine, according to their expectations. We have Deloitte, who will be able to conduct this audit of this particular company. Section 161(2) disqualifies the following from being an auditor: an officer or servant of the company. You remember in our definition of who an auditor is, we said we cannot call you an officer per se, because you're supposed to be detached. So when section 161(2) disqualifies you as an officer or servant of the company, is because you want the company to do well. It is for your best interest if the accounts are made to present fairly and a true presentation. We also disqualify a person who is a partner or in the employment of an officer or servant of the company. This is where we are saying the degree of independence. If I am employed by one of the directors of your company, I cannot purport to come and audit your company. I should be able to be so detached that the performance of your company is only relevant to me if it's being represented, if the books of accounts are being represented in a fair manner. We are also disqualified if you're disqualified for appointment as an auditor by any other body corporate, which the company's subsidiary holding company would disqualify you. So if we talked about a holding company and a subsidiary, Jambojet being a subsidiary of Kenya Airways, if you are disqualified from being an auditor of Jambojet, you cannot again be an auditor of Kenya Airways. So essentially, you are barred from acting as an auditor for either company. You remember, an officer of the company will include a director, a manager, or a secretary. And this is where we are saying you cannot be an officer in this respect, despite you being contracted to work for the company. Your independence must be guaranteed. So how do we appoint these auditors? One, there's the automatic appointment. And the provision for automatic appointment without a resolution, that is of an existing auditor who is willing to continue in the office. And you are retiring, but you're deemed to be reappointed unless you are not qualified for that reappointment and a resolution has been passed at that meeting appointing somebody else, and this officer or this auditor has given the company notice in writing of his unwillingness to be reappointed. But where notice is given of an intended resolution to appoint some person in place of a retiring auditor, and by reason of death or incapacity that disqualifies the person, the resolution cannot be proceeded with due to those issues. That retiring auditor shall not be deemed to be automatically reappointed. And at the AGM, where no auditors are appointed or deemed to be appointed, the registrar may appoint a person to fill the vacancy. In such a case, within 7 days, you must give the registrar notice. And the company failing to give notice means that every officer who's in default shall be liable to a fine. So we talk about first auditors. The first auditors are normally appointed by the board of directors before the first AGM, and they hold office until the conclusion of the first annual general meeting, and where the new auditors will be appointed to take place of those appointed by the directors. Again, before that AGM is held, notice will be sent out to the shareholders that we are appointing auditors. So the ones that held office from the inception of the company up until the AGM is held will then be able to be placed aside if they are not eligible for appointment. Remember, we said the company must hold a meeting within the first 18 months of its incorporation. Once it has come into existence, these 18 months are where the first auditors will have been appointed by the board of directors. So once the AGM is done, they may be appointed, they may be reappointed, or they may be retired. And where the board fails to exercise its power to appoint the first auditors, the power shall cease upon the company in appointing the first auditors. If they don't appoint that, then the AGM is where the first auditors will be appointed. So subsequent appointment, upon the expiry of the term, they're either reappointed or vacancies filled. So how do we fill casual vacancies? That vacancy, if it continues, and this maybe has been caused by the resignation of an auditor, a meeting has to be called to appoint one. And where an auditor is appointed in a vacancy, they'll hold that office until the next AGM. So what you're saying is that there's no vacuum. If an auditor retires, an auditor is declared bankrupt, an auditor is passes on, a meeting is called to ensure that there's an appointment of another auditor who'll hold the position until the AGM.